As promised today, we will be doing a case study for reconsideration. Our client Jaspreet Kaur approached us with her mother's case. Let us look into the facts. She approached us after receiving 2 refusals. One was for visitor visa and the other one was for super visa, both from an unauthorized and an inexperienced agent from her home country. The most recent refusal was for super visa. After our in-depth assessment, we recommended for applying for reconsideration to challenge the officer's decision. The reasons for the most recent refusals were lack of intention to leave Canada, financial stability, and purpose consistent with temporary stay. So this is how we approached this case. After carefully understanding her case, we decided to challenge the officer's decision through reconsideration process. For her intention to leave Canada, we addressed this concern by providing documentations that were missed in the original application. First, we provided the documentations for the business she owns. These were not provided to the officer originally. Additionally, we provided documents of proof of income the business generates. Secondly, we provided documents for her property she owns back home and explained to the concerned officer how this property needs an ongoing upkeep, which is done by our client. Finally, we provided proof of relationship with her son. This relationship she maintains on a regular basis. We explained in the reconsideration how this relationship is important to our client, and this is the primary reason she will be going back in the home country. For her financial stability, we provided updated bank statements, but we did not just stop there. We broke down every single expense for her trip that she is planning to make and proved to the officer that she has enough money in her account to cover every single expense of the trip independently. For the purpose consistent to her temporary stay, we appealed on human and compassionate grounds. We also urged to the officer to reconsider on the basis that the client owns a successful business and is fully aware of repercussions of violating Canadian immigration laws. We explained how overstaying the visa would jeopardize her business and family commitments in her home country, a risk she was not willing to take. Further, we urged the officer to consider that denying the client this visit would not only impede family reunification, but would also have deeper humanitarian implications. In addition to these arguments, we used the principle of natural justice under immigration law to support this case. We specifically argued that the officer's decision violated the following principles: adequate and fair opportunity, lack of detailed explanation, and failure to consider overall picture. As a result, we got a passport request and our client's visa was finally approved. Here are 2 key takeaways from this case. 1. Don't give up after a refusal. If you have been refused a visa, contact us for guidance on how to proceed your case. Remember, each case is unique and the principles that apply to this case may not apply to another. Number 2, do your research and hire an experienced consultant from the start. At Bright Light, we firmly believe in doing it right and doing it right the first time.